In our previous lectures, we have already discussed in detail about the Digital Personal Data Protection Act of 2023, and we have left to discuss Digital Personal Data Protection Rules of 2025, and at present in this lecture we will discuss about the Digital Personal Data Protection Rules 2025, and as regarding the very recommendations made by the Observer Research Foundation in regarding the 2025 Digital Personal Data Protection Rules to Ministry of Electronics and Information Technology, we would like to discuss in detail about the rules. So, the Ministry of Electronics and Information Technology, Government of India released the draft Digital Personal Data Protection Rules of 2025 in early January this year and invited feedback by 5th March 2025, and on 18th February 2025, the Ministry of Electronics and Information Technology organized a consultative session on the draft Digital Personal Data Protection Rules. The event held in New Delhi was attended by the Observer Research Foundation. Based on the consultative session and discussions with various stakeholders and scholars doing work in this domain, the Observer Research Foundation submitted the following comments to Ministry of Electronics and Information Technology Act. So in that regard, we would first discuss about the very introduction. So the Digital Personal Data Protection Act was enacted in August 2023 for processing of digital personal data in a manner that recognizes both the right of individuals to protect the personal data and the need to process such personal data for lawful purposes, while the DPDP Act lays the broad foundation for data protection. The Digital Personal Data Protection Rules 2025, released on 3rd January 2025, clarify the details and address the finer points and confrontation or operationalization of the Act. So, the Observer Research Foundation comments on the Digital Personal Data Protection Rules in the following manner. So, the first comment and observation is regarding registration and obligation of consent managers as per Rule 4 of Schedule, and it is regarding data protection boards, and in particularly under the current data protection framework in relating to registration and obligation of consent manager. The current rules elaborate on the registration, accountability, and obligations of the consent manager. So, Rule 4, read with first schedule, provides for consent management, the obligations of consent managers, and their registration with the Data Protection Board. Consent managers need to ensure that data principals can easily give, review, and withdraw their consent whenever they choose. They also maintain accurate records of all consent related activities and enforce strong security practices to protect this information. These obligations simplify consent management, increase trust, and provide individuals with more control over their data. So, the following are a few areas of concern around Rule 4 and the first schedule that is under Part A of Schedule 1. Several conditions for the registration of consent managers have been provided. However, many terms used leave room for discretion by the board. These include the determination of sufficient capacity to fulfill its obligations as a consent manager, general character of management, adequate earning prospects of the applicant, and where the key managerial personnel and senior management of the applicant company are individuals with a general reputation and regard of fairness and integrity. The board has been entrusted with wide discretionary powers and no guidelines for exercising this discretion have been provided. The schedule calls for subsequent independent certification about the interpretability and that appropriate technical and organizational measures are in place. However, the rules are silent on who can conduct such independent certification or the standards to be applied during such process. Further, there is no guidance on the interoperability standards that consent managers must guide by. Under Part B of Schedule 1, consent managers must take reasonable security safeguards to prevent personal data breaches. However, the rules are silent on what such reasonable security safeguards could be. And the second observation made is regarding the verifiable consent for processing of personal data of a child or of a person with disability who has lawful guardian. So, this is the second most important observation made by the Observer Research Foundation. So, Section 9 of the Digital Personal Data Protection Act requires a data fiduciary to obtain verifiable consent of the parents or lawful guardians for processing the personal data of a child or a person with disability. So, Rule 10 expands on Section 9 and prescribes how such verifiable consent can be obtained. So, these are the important rules and observations through these measures, which aims to protect children's privacy and access to online resources. They may unintentionally cause more harm in many cases, especially in rural and urban poor households. With only one device, the device might be registered to an adult, but it is primarily used by the children and adolescents. Currently, 82.1% of rural youth as 15 to 24 have internet access. As verification in such cases of invisible use will be difficult to validate, and where validation is possible, it could affect digital growth in low access areas or in the rural areas. Under the verifiable parent consent mechanism which provided under Rule 10. Children must voluntarily self-declare to it that a fiduciary that they are children within the meaning of the act while seemingly straightforward. This approach creates challenges in verifying children's consent self-declaration opens a potential loophole as many children may falsify the age to bypass restrictions, particularly in the absence of accessible mechanism for verifiable consent. This undermines the effectiveness of age restrictions and could result in a digital divide. Children unable to navigate the consent process due to technical or systematic barriers may resort to falsifying information, exposing themselves to online risks and being excluded from essential digital services. The requirement under the rules to verify a child's account on an online platform using identity and age details issued by a government authorized entity raise serious concerns about privacy and the fundamental rights of children. The rules propose to the parents voluntarily provide such details using services like the digital locker, but this process inherently compromises the privacy of both the child and the parent by requiring sensitive government issued credentials to verify the parent's adult status. This provision introduces unnecessary surveillance and data collection into the digital ecosystem. This creates a database of personal information vulnerable to breaches, misuse, or exploitation, further impinging or individuals' right to privacy. Moreover, the rules fail to clarify how often consent will be required. Will the verification process be a one-time exercise or an ongoing requirement for every instance of data sharing or account modification? Without such clarification, the burden on parents could become excessive and intrusive, discouraging their participation in digital platforms. This lack of specificity in the rules leaves room for arbitrary implementation and could result in overreach, infringing on citizens' fundamental rights to access and use digital services without undue surveillance or interference. These provisions, while intended to protect children, risk disproportionately affecting all users by normalizing mass data collection and enrolling digital autonomy of individuals. And now we would like to discuss about personal data of persons with disability who has lawful guardian. So under Rule 10, those diagnosed with a disability, specifically those registered under the Rights of Persons with Disabilities Act 2016 and the National Trust for the Welfare of Persons with Autism, Cerebral Palsy and Mental Retardation and Multiple Disabilities Act with severe mental disabilities require consent to be submitted by their guardian to process their data. A few areas of concerns around this provision for persons with disabilities who have lawful guardians are as follows. This provision, while well intentioned, will result in a backward implementation, undermining the urgency and dignity of those with a diagnosis who are capable of autonomy. This clause does not capture the heterogeneity of the disabled population and will contribute to the continued discrimination against the community. It fundamentally disagrees with the Rights of Persons with Disabilities Act 2016 that encourages autonomy and independence in the disabled community. The draft Digital Personal Data Protection Rules highlights a complex issue regarding consent management for persons with disabilities, specifically when their legal guardians are involved. While the rules define legal guardians as those appointed under either the Digital Act or the National Trust Act 1999, they overlook a fundamental difference between these two laws, leading to confusion and potential problems for persons with disabilities. The National Trust Act 1999 follows a substituted decision-making model where the guardian steps in to make decisions on behalf of the person with a disability, assuring they are unable to decide for themselves. On the other hand, the act relating to those personally disabled act, and that is relating to rights of persons with disabilities act 2016, which promotes supported decision making where the guardian's role in the ascent not replace the person's judgment, recognizing that persons with disabilities have the legal right and ability to make their own choices with some assistance when needed. The rules failed to consider these basic differences, which could lead to conflicts in certain situations, such as the following that we found: if a person with the disabilities and has a guardian under the National Trust Act of 1999, does that mean the guardian can make decisions and all decisions about the person's data, even if the individual is able to consent with little or no support from the guardian or someone under the Rights of Persons with Disability Act 2016? With a guardian, what happens if the person themselves wants to consent to data sharing? So, considering the provisions of the Act focuses more on support rather than complete substitution. Are they allowed to do so, or does the guardian still need to step in? So, this confusion is more than a technical problem, it has real life consequences. It risks wrongly assuming that everyone with disabilities lack the ability to make their own decisions. So both the Rights of Persons with Disabilities Act 2016 and also the National Trust Act 1999 both are and international standards like the United Nations Convention on the Rights of Persons with Disabilities are clear that people with disabilities should be able to make their own choices with support if necessary. The draft rules also do not explain what happens if a person with a disability makes a decisions independently without involving their guardian. Would this be considered a violation of the law of the rules? What impact would it have on their digital rights or the relationship with their guardians? These unanswered questions could unnecessarily complicate life for persons with disabilities and their families. It is also unclear how the data of children of persons with disability will be managed, which takes away parental agency. Even within the confines of the rules, as its core, the problem is that the draft rules do not recognize the diversity of abilities and needs among persons with disabilities. They treat everyone under the same blanket rule, which can unintentionally take away people's autonomy and independence. To truly protect and empower persons with disabilities in the digital space, the rules must clarify when guardianship is needed, respect the right to independent consent, and ensure that any support provided enhances rather than overrides the person's voice. And the third important observation made is relating to localization of certain kinds of data which falls under section 10 of the Digital Personal Data Protection Act and Rule 11, Rule 12 and Rule 14 of the Digital Personal Data Protection Rules 2025. And in regards to that, we found that section 10 of the Data Digital Personal Data Protection Act 2023 provides for the central government with the power to restrict the transfer of personal data by a data fiduciary for processing to such country or territory outside India as may be notified. This action allows for the free flow of data across international borders unless the central government blacklists a country by notification. Thus, the Act has broadened India's position on data localization. However, the draft rules try to impose data localization requirements beyond Section 10 of the Digital Personal Data Protection Rules. Under Section 10 of the Digital Personal Data Protection Act 2023, central government has the power to notify a data fiduciary as a significant data fiduciary and require them to undertake other measures consistent with the provisions of the Act, while Rule 12 builds on this power and requires the significant data fiduciary to ensure that personal data specified by the central government based on the recommendations of a committee it constitutes is processed subject to the restriction that the personal data and the traffic data pertaining to its flow are not transferred outside the territory of India. This may be problematic because of the following reasons: that it is a well settled principle that delegated legislation should not travel beyond the purview of the parent act. The general power to make rules is strictly ancillary and does not enable the authority to extend the scope of the general operation of the enactment. In this case, Rule 12 aims to limit the free flow of data as under Section 12. Delegated legislation by nature cannot replace or modify or create new law. It can be struck down as ultra vires. The rules should not go against the spirit of the statute. The rules are silent on the composition of the committee under the rule, leaving wide discretion. Furthermore, the nature of the recommendations is unclear. Whether the recommendations are binding on the central government or not, the rules introduce data localization, which may affect trade, create difficulties for international business, and impose additional burdens on MSMEs. The rules ambiguity on types of data covered by this provision will leave businesses uncertain, and they may preserve India's data protection framework to be opaque. This could erode confidence and impede business expansion and investment in the country. For instance, in the financial sector, Mastercard's response to the Reserve Bank of India's data localization requirements under Rule 14 is not clarified, and other sectors may face similar outcomes. This will increase operational complexity for companies, especially those involved in data driven activities like the artificial intelligence, cloud computing, and e-commerce, where uninterpreted data sharing is essential for innovation and future expansion. And now we'll go to the fourth observation made by the Observer Research Foundation, and that is relating to due diligence for algorithmic software. So, in regards to due diligence for algorithmic software, Rule 12 requires substantially significant data fiduciary to observe due diligence to verify that algorithmic software deployed by it for hosting, display, uploading, modification, publishing, transmission, storage, updating, or sharing of personal data processed by it are not likely to pose a risk to the rights of data principles. So, these provisions raises concern as the rules do not clarify what kind of due diligence is expected from the significant data fiduciary, creating uncertainty about their obligations under this provision. The term algorithmic software is too broad and could encompass any and all computer programs, including artificial intelligence based solutions. Accordingly, the scope and applicability of this provision need to be clarified. And finally, the fifth most important observation made by the Observer Research Foundation is relating to functioning of board as digital office. So, Section 28 of the Act and Section 2 subsection M of the Act deals with this particular provision that Section 28 of the Act provides that the board will function as a digital office and adopt such techno-legal measures as may be prescribed, while Section 2 subsection M of the Act defines a digital office as an office that adopts an online mechanism wherein the proceedings from receipt of intimation or complaint or reference or directions or appeal as the case may be to the disposal thereof or conducted in online or digital mode. The Act requires the rules to expand on the techno-legal measures to be adopted by the board. However, the rules minimally state that the board may adopt techno-legal measures to conduct proceedings in a manner that does not require the physical presence of any individual. This leaves the techno-legal measures under-explained with no further clarification provided in the rules. Those are made as digital personal data protection rules 2025 as exactly the very observation or comments made by the Observer Research Foundation. So we have discussed all those comments and observations made by the Observer Research Foundation on the Digital Personal Data Protection Rules 2025 in 5 different categories, such as the first one, registration and obligations of consent managers as under Rule 4 of Ist.Schedule, and in particularly relating to the data protection boards. And the second important observation and comment is relating to the verifiable consent for processing of personal data of a child or of a person with disability who has lawful guardian as provided under Rule 10, Section 9, data fiduciary and the very act relating to rights of persons with disabilities Act 2016 and the National Trust Act 1999. And the third observation and comment made by the Observer Research Foundation is relating to localization of certain kinds of data as provided under Section 10 of the Digital Personal Data Protection Act 2023 and the subsequently Rule 12 and Rule 14 of the Digital Personal Data Protection Rules 2025. And the fourth important comment and observation made by the observer research foundation is relating to due diligence for algorithmic software, which we found under Rule 12 is better explained that already we have explained while discussing the fourth commenter observation made by the observer research foundation relating to due diligence for algorithmic software. So also finally the fifth important comment or observation is regarding functioning of board as digital office, which provided under section 28 of the Digital Personal Data Protection Act 2023, and also the very definition in that act under section 2 subsection M, and those rules under the Digital Personal Data Protection Rule 2025 relating to rules to expand techno-legal measures, and in particularly the very important function of the significant data fiduciary. So almost all those rules and those important rules relating to these very specific provisions of the Act, that is Digital Personal Data Protection Act of 2023, that we have analyzed and critically make an analysis under 5 different heads that almost we have completed.